Always, 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 please file whatever you are trying to submit to the court orally. Please put those words in writing and file an application or file your written submissions to that effect. I just got off a hearing where the judge reprimanded me for filing my application for supply of the complete paper book after almost 1.5 years of the copy of the paper book, the incomplete paper book being supplied to me. And I explained that I recently got the matter till just about a couple of weeks ago, and I'm not sure about what transpired earlier. But upon instructions of my client, I state that I had received an incomplete copy. I moved an application for inspection of the court file. That was also defeated. The judge says, no, we are very, very diligent with our work, which I know this particular judge not to be diligent, at least when it comes to allowing applications in the court staff of this court, for allowing applications for inspection and allowing applications for certified copies of order sheets and of the various documents. But in any case, the judge reprimanded, I pleaded, and yet, of course, no adverse order was passed against the client, but a final opportunity was granted, and I was, put to the task of doing some more work in the form of applying for a certified copy of the application that has been filed against me, instead of the court directing the petitioner to to supply a copy of the same to me. And the judge says that this is your fault because you did not approach this court on any earlier occasion, and explaining to the court that you have not received a complete copy of the paper book. And of course, the judge is correct. The client's version of events is that we appeared before the court because the petitioner would not appear. The judge would automatically adjourn the matter, say none for the petitioner, adjourn the matter. And that is the reason why I was never able to tell the court, and even when I did tell the court did not record my submission that I have not received a complete copy of the paper book. The court would always say, let the petitioner slash applicant, the applicant in this case, let the applicant come to court, then we will see. And that is the reason why this is a valuable lesson which I have talked about on many occasions, and I keep reiterating again and again, not just for the viewers of this channel, but for myself as well. Whatever you are doing in court, it is far better. 99.99% of the times, it's not an absolute certainty that you must do it. 0.01% of the times, you can avoid doing this, only very special circumstances on a very case to case basis. But just presume, if you want to commit an error, commit it on the side of making the error of filing your written submission slash application. Bring it on the record, so that even if the judicial officer does not take on record your oral submission that this is what I'm saying, at least you have that written thing which is placed on the court file, because the judge cannot refuse to take that particular piece of paper that you are submitting to the court. As long as you are submitting it, it is on the record, and the date on which it is filed is also taken on the record. And most of the times the judge will also record the submission that this particular document, this application, this submission has been supplied to the court, and the court also directs the party filing it to supply a copy of this to the other side. Extremely important lesson for everybody who goes to a court of law. Always, always, always file that thing in the court, type it out, sign it, file it, instead of trying to get away with making that oral submission in the court.